Thank you for joining us today. Welcome to the 2018 Self-Assessment Lessons Learned webinar. My name is Lindsay Guthrie, and I'm a Project Delivery Coordinator for OEM. I'm going to kick off the webinar today by mentioning a couple housekeeping items, followed by a review of some of the self-assessment findings. We're then going to take a closer look at the individual focus topics that were reviewed during the self-assessment and highlight some of the things we learned throughout the process for each one. I'm joined here today by some other folks from OEM that are also going to be speaking. We have Mariano Barrios, Matt Marino, Erica Christensen, Michael Sykes, and Brittany Bianco. So for the general housekeeping items, please keep in mind that this webinar is going to be recorded, and we will be posting it to the OEM training website once that website is up and running again. In the meantime, Pete McGilvery will be sending out an email with a link to the recorded version. Everyone right now is on mute, so if you have any questions, please go ahead and use the chat box that comes with the GoToWebinar. We're going to be pausing throughout the presentation to take questions, and we'll also leave some time at the end to answer any outstanding questions. If there are other people in the room listening with you, please go ahead and take some time to type their names into the chat box now. That way we can keep a running tab on who is attending today. Some of you may have heard these updates during the webinar last week, but there are a couple of things we want to highlight again for everyone to hear that were very positive notes out of the self-assessment. One of them is that of the 470 projects that we reviewed, 456 of them, or 97%, were found to comply with the PD&E manual and the NEPA Assignment MOU requirements, which is a successful practice in and of itself. Another observation we noticed is that the district personnel was very responsive to requests from OEM throughout the process, so a big kudos to all of you guys. And finally, the self-assessment review team wanted to specifically highlight the Section 106 consultation process because it was especially successful in regard to emergency projects, which were abundant during this reporting period given all the storm events. So the focus topics we looked at included noise requirements in the PD&E manual, Section 106 of the National Historic Preservation Act, protected species and habitats, contamination, relocation, and the MOU standard statement. These focus topics were developed through discussions with central office and district leadership, and consideration was given to the previous audit and self-assessment as well. The self-assessment included project reviews in order to determine if they were compliant with requirements in the PD&E manual and the MOU, and that's what this webinar is going to primarily be focusing on today. But the self-assessment also documented results of our NEPA assignment performance measures, as well as the status of any non-compliance observations from last year's self-assessment and audit report. As many of you may know, the reporting period for this year's self-assessment began May 1st, 2017, and went through April 30th, 2018. So all the projects we reviewed were finalized during that time frame. So this is just a breakdown of our overall findings. We found 2 successful practices, 8 opportunities for improvement, and only 4 non-compliance observations. These are all going to be discussed in further detail throughout this webinar, so stay tuned. We're also going to be discussing specific recommendations that cover these findings, and you can find all this information in the self-assessment report as well. FDOT has already taken some steps to address the findings from a self-assessment. These steps include developing an action plan, hosting a statewide meeting with district leadership to review and discuss the findings and recommendations, making some refinements and SWEP to prompt proper documentation and apply relevant standard statements, and finally, updating the PD&E manual to address applicable observations. So with that, I'm going to turn it over to Mariano, and he is going to discuss some of the findings from the review of noise requirements.
Thank you, Lindsay. On the highway traffic noise area, we reviewed a total sample of noise reports for 36 projects, including the sample universe you see on the screen. 11 Cactus EEs, 23 reevaluations evaluations and 2 environmental assessments. This was done to check for general compliance with Part 2, Chapter 18, titled Highway Traffic Noise. In general, all districts are performing well as it relates to noise studies. We did find 2 project-specific non-compliance issues. The 2 are related to abatement considerations for facilities determined to be impacted during the study. The first one was the exterior of a church and a park that were both determined to be impacted, but no abatement was considered. And the second one was related to interior impact of a church, and again, no abatement was considered. We did find a couple of opportunities for improvements. 23 CFR 772 and Part 2, Chapter 18 require that a copy of the noise study report be sent to the local officials. Currently, Chapter 18 has no requirement to document the submission in SWEP. Also, when an NSR addendum is not required to be prepared during design, the reevaluation should include a statement explaining why rather than just saying the name. What are our recommendations to take care of these findings? We intend to remind districts to consider reasonable and feasible noise abatement for impacted special land use locations and properties with interior noise impacts during the highway traffic noise training that is upcoming for each one of the districts, and also the upcoming noise testing meeting. Also, the OEM will update the noise report outline section of the traffic noise modeling and analysis practitioner's handbook to emphasize abatement considerations for special land uses and interior noise impacts. And we will revisit this item in the 2019 self-assessment. Our recommendations are to revise the PD&E manual, Part 2, Chapter 18, Section 18.2.6.2, titled Coordination Requirements and Documentation, to require that a copy of the NSR transmitted letter to local officials be added to the SWEP project file. That would be our documentation that a copy of the NSR was sent to local officials. Also, OEM will add clarification to the reevaluation form for checking NA. The PD&E manual will be revised to justify why an RSA is not warranted. With that, I'll pass it along to Matt Marino.
Thank you, Mariano. So Roy Jackson and I conducted the Section 106 portion of the self-assessment. We're looking at the same approval period, so from May 1st, 2017 to April 30th, 2018. And our sample universe consisted of 40 type 1s, all of which had historic or archaeological resources present in the APE, and 12 reevaluations, all of which had changes in impacts to cultural resources. So the question that we were asking was, is there adequate documentation of analysis in the SWEP project file to support the determination? So we're not questioning the decision or the determination, just the presence or absence of documentation. So after coordination, we had no non-compliance observations. Before coordination, there were a few issues that we found in project files, but only related to emergency repair actions. And we found that our process kind of allowed for that non-compliance, because for emergency repair actions, Section 106 compliance can be completed concurrent with or after the emergency repair action. Our current process did not present a time frame for the after, so we didn't really have a requirement to have documentation in the SWEP file within a certain time frame. So our opportunities for improvement that we identified involved SHPO concurrence documents. We found that they were often contained within craft reports or supporting documentation, and it makes it kind of difficult to find in the project file. So signed copies of the SHPO letter should be located in the project file as separate documents, either in the cultural or the agency coordination folders, or both. We also want to use standard definitive language for Section 106 findings, which is provided in Part 2, Chapter 8 of the PD&E manual. So for example, we're looking for a determination of no historic properties affected, rather than saying that this project will probably not affect historic properties. Our recommendations are that OEM will remind the districts that signed copies of SHPO concurrence letters should be filed as separate documents in SWEPT, and that OEM will include in the PD&E manual Part 2, Chapter 8, guidance on processing emergency projects for Section 106 compliance. So this is a screenshot of the draft PD&E manual with our updated emergency repair action guidance. And the highlights from that are that we can use standard notification forms to notify SHPO of the action. Again, documentation can still be completed concurrent with or after the action, but now we have instituted a 6-month time frame. So you have to have documentation and concurrence from SHPO within 6 months of the completion of the action. If no cultural resources are identified within the APE, Section 106 obligations are fulfilled by the standard SHPO notification letter. Also, documentation is uploaded into the SWEPT project file. So if the action or any additional coordination is completed under a new FM number, which can happen if you're moving from an emergency repair to a follow-up permanent repair, just make a note to the SWEPT project file that explains that situation and tells us where we can find the documentation. And we have options for that documentation. Again, you can use the minor project notification form, or you can just make a note to the project file that explains the scope of the project and the background and cultural resources situation. So now I'm going to pass it off to Erica Christensen for protected species and habitat.
Thanks, Matt. So I'm going to go over our findings and recommendations from the self-assessment for protected species and habitat. I'm also going to go over some additional guidance based on those recommendations. So our sample universe for the self-assessment consisted of 40 type 1s, where ESA listed species were present and that was marked on the form. And then we also looked at 12 reevaluations that had changes to the protected species and habitat. So our questions that we specifically asked for type 1s, we asked if species were present, was the appropriate level of documentation present to support the effect determination? Was it clear that an effect determination was made without relying on the use of FDOT standard specifications? So those are the 2 questions we asked for type 1s. And then for reevaluations, additional questions we looked at were if there were changes and impacts to protected species and habitat, not including wetlands or EFH, were those changes described in the reevaluation form? And then if there were changes to protected species and habitat, was there documentation of coordination or consultation with the appropriate resource agency? In the project file, was a tech memo or NRE available? And then if applicable, was a status of mitigation provided? So the opportunities for improvement that we documented, and these were reflected in the self-assessment summary. For type 1 projects, please ensure that it is explained how the effect determinations were made for each species, either in the form or in an attachment, and this attachment could be either an NRE or, if more appropriate, a tech memo, and that's determined through the NRE guidance. Make sure that clear effect determinations were made without reliance on DOT specifications, and that's standard specifications, and provide the correct name for external agency standard protection measures when they're being included in the project. Some additional opportunities for improvements: if using a programmatic biological opinion that was previously obtained, include the proper name of the BO, the date of which it was signed, and which species it is for. It also may be useful to highlight the end result of using a species determination key in the project file or in an attachment when, so highlighting what conclusion you got from using the key. And then also in the type 1 CE form, it does not require state listed species to be included, but it may be useful to include discussion of that just so that we can clearly document that we're considering all protected species with our type 1 projects. And so our recommendations from those observations, OEM will advise the districts that effect determinations for species and critical habitat should be clearly stated and use standard language as provided in the Natural Resources Evaluation Guidance, which is posted on the OEM website. OEM will advise the districts that all effect determinations should have proper explanations as to how that determination was reached. And then OEM provided recommendations during the self-assessment on ways to modify template language to include in the technical memo attachments for type 1 CE projects to better demonstrate that no significant impacts were proposed to protected species and habitat. So next I wanted to go into that specific guidance that I want to provide to all of you. So one of the first things that we wanted to emphasize was that we're making clear effect determinations using standard language. So a common observation was language that consisted of, because of whatever reason, no impacts to protected species or habitat are anticipated. And instead of using that language, we would prefer to change it to, because of XYZ reasons, there will be no effect to the species or habitat, and specifically saying for which species that is for. And if you're not familiar which standard language I'm talking about, it's in the NRE guidance where you could find that. And so this is the screenshot from the NRE guidance. And so the first three are the standard federal effect determinations for federally listed species. And then the next three, the no effect anticipated, no adverse effect anticipated, and potential for adverse effect, is our standard language for state listed species. And then for state listed plants, they follow similar language for that as well. So the next one is a really important point that I want to emphasize, is explaining how we make the effect determinations. So DOT, we're responsible for determining what we think our effect is going to be on a listed species. And because of that responsibility, we need to document how we're making that determination. So I listed a few examples that could be instances of explaining that determination. So the first one reads, the project limits occur within a heavily disturbed area and no listed species were observed during our field review and had preferred a date to be provided. So a determination of no effect is made for this species or habitat for this project. Another example could be based on actions required to complete the scope of work for this project. No effect is for this species or habitat is anticipated. And because a scope of work, we'd also like to see further documentation that based on GIS review or other field surveys to support that decision. And then another instance could be, although occurrence of this species has been documented near the project limits, no species habitat will be impacted as part of the project, and the project is expected to have no effect on the species or habitat. And although not always necessary, a combination of these types of statements would clearly demonstrate how the project will not have significant impacts to protected species and habitat as required through the PD&E manual. Yeah, we can do a question now.
The question is, do you need to include a description of the scope of work?
So the question was, do you need to include the description of the scope of work? Typically in the type 1, the scope of work is described at the beginning of the form. So I don't think it's necessary to repeat that in the protected species section of the type 1 form. Maybe an attachment, if it's in a tech memo attachment, it may be useful to include that if it's not already described earlier in the tech memo. Okay, so Moving on to the next point. So this was something that we felt would be helpful in our documentation for protected species. So we often use effect determination keys for listed species, and OEM thinks it'd be helpful to include which result we got from using that key. And so you can either document that by including the key as an attachment and highlighting what steps you got to your conclusion, or just simply reiterating the outcome of the key in the form. And I wanted to point out to be sure to include the date of the key being used, because there could be an update to the key and we just want to document which version of the key that we're using. And so this is just an example of that. So by using the effect determination key for wood storks dated May 18th, 2010, the project impact to suitable foraging habitat is less than 0.2 hectares. Therefore, the effect determination is MANLA and no further action is required. So that could be example language that you put either in the form or in an attachment to the type 1, or you could include a screenshot of the key and which end result you got. So that's what the screenshot on the right is showing. And then I wanted to point out specifically what that footnote is. And so just because the determination key gets you to may affect, not likely to adversely affect, it's important to note that from this result, no further action is required per the key. And so that's just an important distinction to keep note of for using these keys, that just because you got MANLA, you need to make sure that no further consultation with the service is necessary. So this is just some guidance to clearly make effect determinations without the reliance on DOT standard specifications. So a pretty common observation that I saw was a statement similar to this. FDOT Section 7-1.4, compliance with Federal Endangered Species Act and other wildlife regulations, or also known as just our standard specifications for unanticipated interactions with wildlife, that will be adhered to, therefore no effect is determined for this species. And the reason that that's not acceptable is because just because we're following our DOT standard specifications, that doesn't give any assurance to the agency that we're not having an impact to the species. So we need to prove outside of our standard specifications how we're not having that impact to the species. So a better way to phrase that could be, because of maybe reasons I listed earlier, like there's no habitat presence, there's no expectations that the species is going to occur there due to field service, that the project is expected to have no effect on that species. And then if you wanted to include the standard specifications, to include that after you make the effect determination. A better way to put it would just be based on whatever reason your project is expected to have no effect on the species, and not include standard specifications, because it's already understood that we're going to be following those for all of our projects. We also want to, so for some guidance for reevaluations, we want to verify listing changes since the last reevaluation or the original environmental document. And so I listed a few common changes that we see in the reevaluation. So the first one, the FWC's Imperiled Species Management Plan, that was approved in November 2016, which changed many of the state listing statuses for species commonly included in projects. For example, white ibises, little blue heron, Florida pine snake. And then some federal protected species listings may have changed since the approval of an original environmental document or subsequent reevaluations. For example, the Fish and Wildlife Service reclassified wood storks from endangered to threatened in 2014. And so you just want to document that and update that in a reevaluation if you haven't had one since that change. And then some other relevant changes include the bald eagle being delisted but still protected by the Bald and Golden Eagle Protection Act, and the Florida black bear being delisted from the state but being still protected as a managed species by the Florida Black Bear Conservation Rule. And so a helpful tip here is to please compare the species list from the original environmental document or previous reevaluation and list those changes in the new reevaluation. And next, I just wanted to go through some successful practices that we documented in the self-assessment. So this district successfully demonstrated how their type 1 projects will not have significant impacts to protected species by providing detailed narratives that explain their data gathering, field reconnaissance, their effect determinations, and how these were reached. So this was for a type 1 project, and you can clearly see, their list of species that they thought could be in their project area, and they outlined, some basic information like where they're normally found to occur, an explanation as to why they're determining their effect determination, and then giving a conclusive statement of their effect determination. So, for example, for eastern indigo snakes, the federally threatened eastern indigo snake is found throughout Florida, but is rare in most areas. No eastern indigo snakes were observed during field investigations, and there's low potential for their occurrence in disturbed area with limited natural habitat. Therefore, the project will have no effect on the eastern indigo snake. That was very clear to me, and I thought that was a great example. And then this was just another example that I saw on a specific project where they documented using a key in their documentation. So you can see they included the name of the determination key that they're using, the date, and the outcome of using that key. Last, these are just some helpful resources for everyone. The Natural Resource Evaluation Outline and Guidance, or Part 2, Chapter 16 of the PD&E Manual. I also linked FWC's Florida and Endangered Threatened Species list, which was last updated May 2017, and that includes a helpful table on page 13 of listing changes since 2010. And then also, of course, FWC's Imperiled Species Management Plan, page 18, has a really helpful table summarizing the changes listed in the ISMP. And with that, I'm going to move over to Michael.
Thank you, Erica. I want to go over the self-assessment findings for contamination. So the sample universe, similar to the other issues, is 40 type 1 CEs, 8 reevaluations, 10 type 2 CEs, and 2 EAs. Our method for determining compliance was if the contamination screening was evaluated, the contamination screening evaluation was completed and documented. We had a few opportunities for improvement. First, we found no projects out of compliance. All projects had some level of contamination screening evaluation done and some documentation. The opportunity for improvement is surrounding how the projects were documented, or the contamination screening evaluation was documented. They weren't consistently using the tech memo for contamination screening. Projects use the type 1 CE memorandum or project impact assessment surveys and other forms to document the contamination screening evaluation. There was a successful practice that we found. One project re-evaluated the contamination screening evaluation. They went and rescreened the project for contamination after the level 1 CSER produced no contamination or found no contamination issues in the project. And recommendations are to consistently document contamination with the tech memo, OEM, remind district fair documentation, and also share benefits of rechecking the contamination database to help ensure contamination will not be encountered in the projects if things occur, or if a new contamination is added to databases between PD&E and construction. And with that, I will pass to Brittany.
Thank you, Michael. So I looked at relocation with 2 Clark. Our sample methods, and specifically the sample universe, is a little different. So we originally were planning to look at type 1 CEs and reevaluations for relocations. However, early in the process, it was determined that there were not enough relocations on type 1s to really warrant and accurately evaluate the process. So with that, we decided to look at all approved type 2s and all approved EAs within the reporting period. Our methodology, essentially we were looking at the documentation for reevaluations and was it adequate in the SWEP file to support the determination. In this case, we were not questioning any of the decisions being made or the determinations, just whether or not the documentation was there. So we had 2 non-compliance observations with relocations, the first being that the standard statements were not included in the document that are in the chapter, and that the CSRP was also not included in the project file. We noticed that an opportunity for improvement was whether or not to clearly identify if a relocation is anticipated for a particular project. So the recommendations that came out of this was that OEM will issue a reminder to clearly identify whether a relocation is anticipated for the project. Some examples that we would be looking for are listed on the screen. So for example, the project will not result in any relocations of persons or businesses. The project is being conducted within existing FDOT right-of-way, therefore there will be no right-of-way acquisition required. The second one shows no relocation is anticipated, and the third shows that the widening of US 98 will result in the relocation of 4 residences and 4 businesses, clearly showing that we are anticipating relocations on a project. We also will provide a statewide reminder to utilize the standard statements in the PD&E manual. And we will also be looking at this again in the 2019 self-assessment. We will also issue a reminder that the conceptual stage relocation plan needs to be included in the project file. And again, this is something we will look at next year. So as a result of the self-assessment, we took a deeper look at our chapters and provided a chapter update that will be released when the chapters are published this year. On the left, you can see what the current chapter states and on the right is the new update. So the current chapter states that a conceptual stage relocation plan for when relocations are anticipated will be prepared by the right-of-way office. However, upon further review and working with the right-of-way office, we determined that this conceptual stage relocation plan is actually completed by the environmental office in conjunction with the right-of-way office. We also have added, if you read further down, that if it is minor relocations on a project, that we can prepare a memorandum instead of a full conceptual stage relocation plan. If you have questions on whether or not a project has minor relocations, contact your OEM PDC and they will be able to assist and help determine whether or not a full conceptual stage relocation plan will be required. This will be determined on a case-by-case basis based on the project. Okay.
The question is, if the standard statements are in the previous document, does it have to be reprinted again? I think we probably need some clarification on that one.
Are you talking, the question was whether or not the standard statements in a previous document, if they need to be reprinted again. Is that in regards to a reevaluation?
Have the statement again for a reeval, it only be in the main document.
Yeah, so we will only have the statement in the main document, so the type 2 EA, EIS, and in some cases also the type 1, which we'll discuss in a bit. So, however, it does not need to be included in a reevaluation. So let's see here.
The chapter is pretty clear about this document.
Yeah, and the chapter does outline directly which and where those statements need to be included in the directions prior to the statement itself. Another change that we did was the standard statements themselves. They were
fairly robust. So we tried to streamline a little bit more and make it more clear. So on the left, you can see the standard statement for when a relocatee is involved. And on the right, you can see when there are no relocations, the standard statement that needs to be included in the project file. For type 1s, type 2s, EAs, and EISs, all document levels, the relocatee, if there is one involved, has to be in the document. However, for no relocations, that statement is only required on type 2s and above. If you have questions on this, feel free to let us know. We also have created standard statements for state documents. They are shown here. So whenever you do a SEER, please include whichever appropriate relocation statement in the file.
We have a question.
Okay.
Do we have staff hour estimates to complete a CSRP? And the question, the answer to that is it should be in your PD&E scope, so there should be appropriate staff hours for that.
Okay, so finally, just wanted to go over just some of the additional changes. We are requiring a CSRP or memo when there are relocations on a project. This needs to be included in the project file to be determined complete. We clarified that the standard statement for when a relocatee is involved is required on all classes of action. And the last resort housing language in the chapter is also required for all classes of action. There is an alternate statement for the last resort housing available in the chapter for when a SEER is being done. So with that, I wanted to open it back up if there are any additional questions on relocation. Okay, and with that, I'm going to give it back to Lindsay.
Thank you. Okay, this is the final topic for today, and it's the MOU standard statement, which is pretty straightforward. Our sample universe included type 2 CEs, environmental assessments, and reevaluations. The question we asked when reviewing each project was, is the MOU standard statement found on the cover page of the qualifying documents that have been finalized after NEPA assignment? So when I say qualifying documents, I'm referring specifically to NREs, CRASs, PERs, and public involvement documents, which mainly consisted of the public hearing transcript, the PIP, and the comments and coordination reports. So essentially, we were just looking at all these qualifying documents to see if, one, they were finalized after NEPA, and two, if the MOU standard statement was on there. So before I go over the outcome, I just want to review what the requirements are per the MOU. Section 3.2.5 states that the MOU standard statement should be on the cover page of each biological evaluation or assessment, historic properties or cultural resource report, Section 4F evaluation, or other analysis prepared under the authority granted by the MOU. So for convenience, we have a technical report cover page template with the MOU standard statement already on it, and it can be easily attached to all of your technical documents, and it's shown on this slide there on the right. This template can be found on FDOT's employee portal under the Forms Management tab, and the form number is listed on the bottom of the slide. Section 3.2.6 of the MOU states that FDOT shall disclose the MOU standard statement to the public and agencies as part of agency outreach and public involvement procedures. So therefore, we did not expect to see the standard statement on the cover pages of the public involvement documents, but we just looked to make sure that they were mentioned somewhere within the document. And for anyone who may not recall what the MOU standard statement says, you can read it here on the bottom of this slide. Another thing to know is that any documents that are generated through SWEPT will automatically have this standard statement on it already. So it's really just the technical documents and the public involvement documents that you would need to manually put in unless you were to use the technical report cover page template that we have. So of the project files that we reviewed, we only found one non-compliance observation, and there were 3 occurrences of this happening. 2 of them were on PERs, and there was 1 NRE that did not have the MOU standard statement on it, and they were also finalized after NEPA assignment. Just as a note, we did find some other occurrences where we did not see the standard statement on the cover page of the technical report, but it was within the technical report on one of the subsequent pages, so we did not count those as non-compliant. The non-compliant ones were the documents that did not have the MOU statement anywhere in the document. So our recommendation to address the non-compliant observation is that OEM provide a statewide reminder to include the MOU standard statement on the cover page of your environmental analysis documentation, such as the PER and the NRE, and that OEM is going to revisit this non-compliance during the 2019 self-assessment. So, do we have any other questions from previous topics?
Yeah. Can you actually go back to slide 31, Lindsay?
Okay.
I would just probably. Okay. Yep. No, you're on it.
Oh, okay.
So the question was about using effect determination keys and getting MANLAs or may affect, not likely to adversely affect. And the question was, can you get a MANLA using keys and not need consultation? So you can see in the footnote here, the number 1 at the very bottom of the slide, that with an outcome of no effect or not likely to adversely affect as outlined in this key, if the project has less than 20 hectares of wetland impacts, the requirements of Section 7 of the Act are fulfilled for wood storks and no further action is required. It's really important to point out that no further action is required, because if it did not state that, we would still need to coordinate with the service. So unless it's specifically said in the key, MANLAs require coordination with the service per usual procedure. If it specifically says no further coordination or action is required, then we're okay.
Okay, we also had one more question, and this is for relocation. And the question is the standard statement required for the conceptual stage relocation plan? And I'm not sure exactly what that question is, but the response to that is the standard statement for relocation, whether you need relocation or you don't need relocation, is included in the environmental document. So hopefully that answers that question.
And for type 2s, with the new form that went live this week, that standard statement, either one of these, depending on your selection on that form, will automatically be included in the document, so you will not have to type this on type 2s. The rest of them, though, for right now, you will.
Oh, and one more question came in, the MOU standard statement. I guess where does that need to be? So it needs to be included on the environmental document as well as the technical report.
So it needs to be on the cover page of your technical documents and your environmental document, and it needs to be disclosed somehow within your public involvement document. So for a public involvement transcript, usually we would see that, during the introduction of the public hearing transcript, during the introduction, they would read the standard statement, and that would suffice. Okay. Since there are no more questions, I just wanted to thank you all for your time and attention during the webinar. Just another reminder that this was recorded, and we will be sending out the presentation and the recording shortly. And if you have any additional questions, please feel free to contact Pete McGilvery or Katasha Cornwall. So, thank you.